May I please, your lordship? My lord, item number 35, perhaps diary not received.
Item
35.
35 not received.
My lord, cyber PS, Panbazar.
Okay, on the pair being made by Mr. Pramanik, learned counsel for the applicant, rest shall lodge the matter when over.
Sir, as you hold 15.
Cyber PS, Panbazar.
21.
My lord,
21 of this month. On that day, learned additional proposal, what is the case ready before this court?
highly appreciate.
May I please, your lordship, the item number 24, lordship. Adjourn for Rode, lordship.
24, yes, yes,
On
yes.
the pair being made by Mr. N. Ahmed, learned counsel for the accused, rest shall lodge the matter on
Next week, any date, lordship.
when?
29, lordship. Another pair, lordship, the for Woodell, lordship, on tomorrow, lordship.
Okay,
And another pair, lordship, the regular bill, the same FIR, they are still on the same deal, lordship.
When?
The fixed on tomorrow, lordship, item number 8, lordship.
how many matters are there?
Tomorrow, item number 8. BA number 1273. Same FIR, same day, lordship.
Not tomorrow, day after tomorrow.
This matter for listing matter, day after tomorrow.
When?
Day after tomorrow.
Day after tomorrow.
May I please your lordship, I beg to mention item number 34. Probably my lord, CD is not,
CD not received.
interim is there, my lord.
Okay, on the pair being made by Mr.
J. Ali, my lord.
J. Ali, learned counsel for the applicant, rest shall lodge the matter on when?
Interim is there, so my lord 29.
29.
Third June, yes.
On that day, learned additional PP shall produce the case before this court. Until then, interim order pass early shall continue.
I'm obliged.
May I please, your lordship? I beg to mention for listing of criminal appeal.
When?
Any last week of this month.
Next week.
Last week of this month, any date.
Okay.
Not surprise.
May I please, your lordship? I beg to mention for listing on criminal petition 414, 2023,
When?
for next week, any day.
Take it that from.
May I please, your lordship? I beg to mention listing of a anticipatory bail, lordship.
When?
Day after tomorrow, lordship.
Possible.
On 20, Monday.
Obliged.
May I please, your lordship? My lord, I beg to mention item for listing of a criminal petition, my lord.
When?
My lord, Monday, my lord. Most obliged.
May I please to your lordship, this is a mention memo for listing of a criminal revision. Kindly this matter next week.
24th.
24th.
Yes, please, your lordship. Lordship, I beg to mention item 33 of the Delhi list. Lordship, CD is not there, so
Yes, diary not received.
there is not been issued. There-
33.
33,
The
lordship.
pair being made
There's
by
an interim order, lordship. Kindly
AK
continue.
Sopi. Your AK Sopi,
Yes, lordship.
learned counsel for the applicant, rest shall lodge the matter on Google.
5th June.
5th of June.
Obliged, lord.
Are you on interim?
Yes, interim
Yes,
is there.
interim. Yes,
Till then, interim order pass early shall continue. On that day, learned additional PP shall produce the case.
obliged.
May I please, your lordship, I am praying for listing of a bail application, my lord. Tomorrow, my lord, if possible, or day after tomorrow, my lord, if
Day
possible.
after tomorrow, we
Apply.
have lot of matters.
May I please, your lordship? I beg to mention for listing to criminal appeals and list the matter 20 on 1 or 23.
Okay.
1 on 21, 1 on 22nd. Two cases.
Yes, lord.
1 on 21st, 1 on 22nd.
May I please, lordship, I beg to mention for listing of a criminal revision, my lord, for Monday.
Monday.
My lord, I beg to mention for listing of this case, my lord, this is a regular bail, my lord. I have filed this on 13 and I am requesting
When do you want?
tomorrow, my lord.
Tomorrow not possible.
My lord, urgency is there, my lord, because
Maybe.
my lord,
But tomorrow
Day after.
probably possible.
One case, which is urgent.
One.
One case,
Okay.
which is urgent.
tomorrow, my lord. Obliged, my lord, highly obliged.
May I please, lordship, with regard to item number 45, my lord, Lordship, steps were taken day before yesterday, my lord. So service is awaited, my lord, in this matter. So I pray for taking up this matter after 2 weeks. Any date, my lord.
On the pair being made by Ms. B. Bora,
Lordship,
learned counsel for the petitioner, raises and lists the matter after 2 weeks.
On 38, 305.
Lordship, interim order is there, madam.
Till then, interim order pass or lesson continue.
I'm deeply.
May I please your lordship? Lordship, I beg to list an item that is criminal petition 1251 of 2023.
When?
Next Monday, 25/24.
On 24,
20 Mondays.
on Monday.
20. Monday 20.
Monday 20.
Obligation. Actually, I beg to mention for listing of a 439 bill application, possible tomorrow,
Not possible.
day after.
May I please your lordship, victim item number 29, you should. Matter will be adjourned for the day, your lordship.
39,
29,
29. 29 diary receipt.
matter will be adjourned for the day.
Why?
Senior counsel could not be present before the honorable court.
I will your senior counsel.
DJ Harvey.
On the pair being
Some
made by
medical
Mr.
emergency.
What is your name?
R. Burman.
R. Rahman, learned counsel appearing on behalf of Mr. DJ Halway, learned counsel for the applicant, raises and lists the matter on. Gogoi,
My lord, diary available, any date, kiti like?
1 week. Your Honor.
when?
1 week.
My lord, on 24, yes.
Till then, CDB retained. Yes,
I'm praying for listing of a pending criminal petition for admission, lordship.
When?
22nd, if possible, lordship. Of lordship.
May I take the lordship? Prayer for listing the criminal revision petition for orders.
when?
Day after tomorrow,
On 22nd.
22nd. Okay. Obvious.
May I please your lordship? Lordship, in respect of item number 32, I think charge sheet has already been filed.
Yes, 30 to 30 submit.
32.
Yes.
But my only prayer is, humble prayer is, there is an interim order which may be continued till we appear. Lordship.
Bobby, this matter 32. So we will call the matter.
Lordship. Much.
May I please?
Yes.
I beg to mention item number 13, lordship, 13. What a maybe password for the day, lordship.
Why?
Motions.
Senior some personal difficulties, lordship, today. It's on day after tomorrow, lordship.
Bobby, this is motion matter.
Motion.
Personal matter.
Okay, on the pair being made by Mr. Kelly, learned counsel appearing on behalf of Mr. Ms.
It's on, lordship.
Tyson, learned counsel for the applicant, raises and lists the matter on
Day after tomorrow, lordship.
day after tomorrow. Yes,
Lordship, beg to mention for listing for letters, orders, lordship. Criminal
when?
revision application on 21st, lordship.
Okay.
of this.
I beg to mention one TRP criminal and one criminal petition, lordship, for admission
When?
on Friday, lordship.
Friday, not possible.
22nd. Actually, it was fixed on law trial court on 21st, lordship. Kindly maybe on Friday.
On Monday, we'll check.
Monday. No problem.
May lordship, item number 17. Lordship,
1 second.
What 7?
lordship,
Admission.
Yes.
kindly pass over for today, lordship. Lordship, if possible.
You are for the petitioner or respondent?
Respondent, lordship. On behalf of respondent.
Respondent.
Consent is been taken, lordship.
Respondent number?
On behalf of PK also.
Did you inform the other side?
Yeah, consent has been taken.
When?
Yes, lordship. It has been informed, lordship. 17.
17, my lordship may fix it on 22nd, my lord.
22nd.
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 Okay, with consent from the other side, Mr. Your good name?
S. Kashyap, lordship.
Learned counsel appearing on behalf of Mr. P.K. Roysodu. Raises and lists the matter on
22nd, my lord.
20. Is there any interim order?
No, my lord.
No.
No.
Okay.
Yeah, please, Lordship, I beg to mention, Lordship, item number 16, Lordship.
Mm.
Lordship, the matter may carry adjourn only for the day, Lordship.
Mention Lisa.
On the pair being made by Ms. M.R. Devi, learned counsel for the petitioner. The case is then adjourned to be listed when?
27?
Yes, sir. Lordship.
May, item number 23, day before yesterday, one additional affidavit has been filed. So that additional affidavit may be bring on date of
Items from daily list for motion bail application. Item number 1.
May have the lordship, second bail application lordship. And it is directed by the lordship, that is the case number 40 is the order lordship. Lordship, the petitioner arrested on the basis of the statement of co-accused lordship. Nothing has been recovered from the possession of the prisoner lordship. Sir, seated matter. Already 6 witnesses have been examined lordship.
How much? How many?
6 witnesses have already examined.
Whether they have implicated you?
No, they have not issued anything against the petitioner lordship. Out of 11 issued witnesses. Gati দিছা নেকি এখানে? হ্যাঁ, হেকিটা মোক হাইটা না। He was arrested on the basis of a CDL also. This is page 37, last portion lordship. In the charge sheet lordship.
So what is the ground for filing this second application?
See, he was only arrested on the basis of CDL lordship. I want to submit an argument lordship. Seated matter related to LCR come my lord. See, 5 already examined, 5.
Heard Mr. N.J. Gogoi, learned counsel for the applicant, accused, and also heard Mr. B.B. Gogoi, learned additional briefing for the state respondent. This application under section 439 services preferred by accused. What is the name of the accused?
Tulan Hazarika.
Tulen Hazarika. Tulen Hazarika, who has been languishing in jail in connection with NDPS case number 18 written bracket P 2023 under section 21C sub 29 of the NDPS Act, pending before the Court of Learned Special Judge Principal for granting bail. Mr. Gogoi, learned counsel for the accused, submits that this is the second bail application preferred by the accused, and the first one being BA number 77 of 2024 was dismissed by this court by order dated 22/1/2024 after purging the case. And the ground for filing of this filing of the present petition is that the prosecution side has examined as many as 6 witnesses. Out of how many witnesses?
Out of 11. Out of 11 witnesses.
Out of 11 witnesses cited in the charge sheet, and the 6 witnesses examined so far has not implicated the present accused. With that as in mind, we appreciate the submission of Mr. Gogoi, learned counsel for the accused. Perusal of the record of the learned court below is found to be necessary, and accordingly it is provided that rest is call for the scanned copy of the record from the learned court below, and also an up-to-date status report fixing the matter on
29th May.
29.
Highly obliged.
Item number 2.
Wait, please, your lordship. Call proceeding, my lord. Kindly call proceeding.
Here, my lord, POXO section is there.
So HSS notice will go.
Yes. We will take steps upon resolution number 2.
Lordship will find in the additional affidavit page 32. It transpired, my lord, no prima facie case made out against the petitioner. No whisper even.
No, but the other witnesses,
My lord, is the my lord main
on the
case.
basis of
Yes,
only
hearing
2
witness,
witnesses,
That PW1, my lord, they have annexed, my lord.
PW1 also, my lord, we have annexed, my lord, at page 20.
We intercepted the main accused on the main road near Gutelpara area. When accused saw the police party, he threw the suspected contrabands from his possession. That is.
This PW1 has implicated you.
My lord.
PW1 has implicated you.
Yes, but PW2, my lord, Yes.
Maybe PW2
Is
may
that
be.
witness?
yes, Caesar witness, my lord.
Oh, why should we disbelieve PW1?
In that case, my lord, PW2, my lord, Caesar witness.
Hmm.
There is no materials, my lord. As far as evidence, my lord.
No, on the basis of that witness, we cannot decide the matter. No, we have to read the entire evidence. Is pending before the court of
My lord, special judge, my
Dhubri.
lord, Dhubri, my lord.
Let us wait and see some more other witnesses, evidence of some more other witnesses.
Yes, in
Instead
that
of,
case, my lord, let it be fixed, my lord, in the next week, my lord.
Next,
Next week.
Long date. Lua.
when the next
Have to
date is
come and
fixed.
examine.
My lord.
Next date is fixed when?
Next date, my lord, that is not, my lord, given. That is not, my lord, reflected in the order, my lord. Page
So,
40.
as agreed by learned advocates of both sides, Resist shall raise the matter after 2 weeks.
My lord.
In the meantime, Resist shall call for up-to-date status report from the Court of Learned Additional Session Judge Dhubri.
Yes. Special judge additional.
Learned Special Judge.
Hey, Junior must have got it.
Yes.
On 12 June,
Well. Deep
item 26. Privilege of ownership. At this stage, my lord, I'm seeking default bail, my lord. The petitioner, my lord, he was forwarded to judicial custody on 11/3/2023, my lord. His 180 days completed on 8/3/2024, my lord. But
The
you get
meantime, search is submitted. Also.
no, no, sir, beyond statutory period. That is my case. Sir, he submitted beyond statutory period. And my case is that, my lord, after expiry of the statutory period on 11, statutory period had completed on 8/3. On 11/3/2024, investigating officer submitted application seeking some for time for further investigation. That is also fine. Page 22. It is reflected in the order itself, my lord. When I move in a bail application seeking default bail, it is page 18.
So, there is one direction of the court that the parties have to address the issue with reference to section 9 and 10 of the General Clauses Act. What was the issue?
In that case, actually what happened on 8/3/2024, on that mandatory for 180 days was completed.
No, this reference to section 9 and section 10 of the General Clauses Act.
Because my lord, on 8/3, it was, my lord, mandate was coming on 8/3/2024, on that day, it was holiday. An application made by the IO on 11/3, that is beyond mandatory period. That's why this honorable court directed to address the issue regarding section 9 and 10 of the General Clauses Act. But section 172, 167, subclause 2 clearly says, and that is reflected in the recent judgment of the Honorable Apex Court, says that my lord, section 167(2) provides, my lord, clear mandate that investigator officer must collect evidence within prescribed period of limitation, filing which the accused cannot no longer be detained in jail. And this right cannot be taken away under any unforeseen circumstances, even during my recent pandemic situation. It is clear from the material available record that my lord, mandatory period was completed on 8/3/2024. Within that period, my lord, IO did not file any application seeking extension of time for further investigation. So carrying out further to my lord. On 11/3, that is beyond mandatory period, they made an application
Okay, it is General Clauses Act.
on the ground of being non-receipt of FSL report.
So, where is the search sheet?
Such it is filed, it is submitted beyond a mandatory period.
That's all right, but
That
if you
I
have-
would enclose, my lord, that is the application filed before filing of the charge sheet. The application was moved before December, before file.
you have not brought on record the search sheet.
No, my lord, why they file this application that during that moment, charge sheet was not submitted. Charge sheet was submitted.
Subsequently, you could have filed the search sheet.
If you know, then
By
I'll bring on
filing
record,
an
by
additional
filing additional affidavit, I'll bring on record.
But without the search sheet, how can we say that when it was filed?
The last occasion, my lord, the Lanet PP submitted.
His lordship, charge sheet,
No. Whether search sheet is available with you?
no.
No. I don't know. How can
Then you also call for my lord, call for order, my lord. The section 10 of the General Clauses says that if it was holiday. And
LCR was not called for?
not yet called for.
So if we call for the LCR, then it will serve the purpose.
My lord.
Heard Mr. FKR Ahmed, learned counsel for the accused, and Ms. Hendas, learned additional PP for the status contact. Mr. FKR Ahmed, learned counsel for the accused, submits that during the pendency of this petition, the IO has completed investigation and submitted search sheet beyond the period of 180 days. And as such, the accused is entitled to default bail here in this case. But the said search sheet has not been placed on record. And in order to appreciate the submission of Mr. Ahmed, learned counsel for the accused, perusal of the record is found to be necessary, and accordingly it is provided that Justice shall call for the scanned copy of the record from the Court of Learned Special Judge Sankardev Nagar Huzai, fixing the matter on
29.
short date, sorry,
24.
24.
5, yes.
Item 27.
Lordship, 27 and 28 after some time. Lordship.
Why?
Lanet PP Lordship, B Gogoi has done through this.
Okay.
Oh, Lordship, yes. 27.
May I please the lordship?
Yes.
So this is 439 application lordship. Page 49 days lordship. The FIR is on page number 14. May I read, lordship?
It's number 19,
Page number 14,
14.
Annexure C. May I read?
Hmm. Yes.
Lordship, humble submission is that on 27 to 24, two persons, namely Sri Lakshajit Goswami and Sri Ankur Bora, made phone calls from me from mobile number so and discussed me with that they would provide me a well-functioning tractor in exchange of my tractor bearing number so and also told me that I had to give rupees 30,000 while doing the exchange. Accordingly, around 12:30 p.m. on that day itself, they visited my house and took my tractor to Nagaon with the help of recovery van by persuading me. They also took me along with them by saying that they would provide me the tractor at the tractor dealer in Nagaon. Thereafter, the aforementioned person made me alighted from the vehicle near the sentry gate of Nagaon Morigaon and they fled away. As I become helpless, I called them over phone, and although they told me that they would provide me the vehicle within 4 or 5 days, but they have been keeping their phone off at present. Subsequently, the FIR was registered at Tokmoka PS case number 1 under section 403, 406, 419, 420, and 34 I guess. Lordship, the petitioner is a psychiatric patient, Lordship, and the medical documents are Annexure A. Lordship, he is taking medical treatment from LGB.
Annexure 10, that page number
Annexure 11.
11, page
Page
number.
No, page 11.
Page 11, Annexure A, Lordship.
This is prescription only.
Prescription, Lordship. He is taking medical treatment from LGB Regional Institute of Mental Health.
Hmm.
Lordship, that's full, Lordship. And the main accused, Lordship, Ankur Bora, he is associated with tractor dealer, Lordship. And petitioner has never allowed to go outside without the help of the other person, Lordship. And the main accused, Ankur Bora, he is till then not arrested, Lordship. And he is the neighbor of the petitioner, Lordship.
So how many days you were behind the bar?
49 days, Lordship.
49 days. Gogoi, you received the case diary?
Yes, Lordship. That Ankur, my lord, blame my lord Laksha blame Ankur, my lord. That is their statement. Ankur কৈছে সি মোক মিছাকে মই একো নাই বুলি কোৱা। লক্ষ্যই অংকুৰেহে জানে, অংকুৰে লক্ষ্যই জানে, এইটোৱে সিটোৰ ওপৰত হেৰি কৰিছে।
It appears that you are a habitual offender. You were in jail in connection with one Samaguri PS case in the year 2023.
Lordship, I have no knowledge about Lordship, but the petitioner is a mentally sick person. He has no knowledge about the alleged incident, Lordship.
That person was also arrested,
No, Lordship.
like this Ankur Bara.
No,
Ankur, yes, Ankur statement is there, my lord.
So he
Like
was
my
arrested.
second, last flag, my lord.
So the tractor was recovered.
It is recovered.
When it was recovered?
That is not, that some statement it is, I have found, my lord. I see, no, tractor. नाही ते आता स्टेटमेंट मग चालू सीजर देखो नाही घेतो
When the tractor was recovered?
that is my lord জানা তো নাই
Who was it that
yes
heard Mr.
TP Pupam. TP Pupam.
Learned Counsel for
দিব
the
মোক দিব right let to solve it
accused and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. This application under section 439 services deferred by accused Lakshajit Devagoswamy, who has been languishing in Jailazot in connection with Dokmaka PS case number 1 of 2024 under section 403, 406, 419, 420, 3486 since 28/3/2024 for grant of bail. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Rajan Teki on when it was filed, FIR
60/24.
on 6/3/2024. The essence of allegation made in the FIR dated so is that on 27/2/2024, two persons, namely Lakshajit Devagoswamy and one Ankur Bara, had taken the tractor of the informant Rajan Teki on the condition that they will provide a good tractor to him. And they also told him that if he want to exchange the tractor, then they will provide, he had to provide a sum of rupees 30,000 to them. And thereafter taken him to the dealer, tractor dealer of Nagaon. And thereafter they have fled away. Mr. Popon, learned counsel for the accused, submits that the accused was arrested on 28 June 2024, and since then he has been languishing in jail for last 49 days. Further, Mr. Popon submits that the accused is suffering from mental ailments and he has been taking treatment at LGB Mental Hospital Task Force, and in support of his contention, Mr. Popon has referred to Annexure B at page number 12 of the petition. 12 and 13. Page number 12 and 13 of the petition.
Annexure 11 is.
Mr.
Annexure A.
Popon further submits that the tractor which the accused and one Ankur Bora had allegedly taken away from the informant has already been recorded and seized by police. And that the accused is ready to cooperate with the investigating agency and therefore it is contented to allow the petition. On the other hand, Mr. Gogoi, learned additional briefly, submits that the IO has collected some materials in support of the allegation in the FIR. And therefore, Mr. Gogoi has opposed the petition para, having heard the submission of learned advocates of both the parties. I have carefully gone to the petition and the documents placed on record and also perused the case ID with the assistance of Mr. Gogoi, learned additional briefly. You got it, Gogoi?
Yes, my lord, this statement of Nizamuddin Ahmed, 164 statement recorded. Nizamuddin passes it, my lord. He is saying in his statement,
No, my
moi
question is,
tractor loi gusi ahu. That tractor is with Nizamuddin Ahmed, my lord.
no, when it was
That
recovered,
Caesar list is not here, my lord.
but it is recovered.
But it is Nizamuddin in 164 statement said that moi tractor khon loi gusi ahu. That is his statement, 164 statement. Police not seize or seize, that is not here, my lord.
It appears from the case ID that the IO has achieved substantial progress in the investigation of this case. And the accused has been languishing in jail for last 49 days since his date of arrest on 28/3/2024. And that the accused is also suffering from mental ailments in view of the documents plus at page number 12 and 13 of the petition. And in view of the progress of investigation, as well as the length of detention of the accused in jail as further custodial detention, in the interest of investigation, seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the learned chief judicial magistrate. Ujai?
Caribbean law.
Caribbean?
Which case? Caribbean. Yes.
Caribbean law. The accused be enlarged and back. Case very return.
Yes, diary receipt.
Lordship, the FIR in a page number type, a copy in page number 8, Lordship. May I read, Lordship?
Yes, Gogoi, is there any material?
Material, my lord, he's veteran, my lord, he's once he one statement admitted everything. It is ridiculous. No, bisa. Maksimal material. Asik.
So except the statement of the accused person, is there any other evidence?
Only that he is doing this type of my lord, that. But nobody was there to identify.
For how many days he is behind the bar?
17 days.
19 days.
19 days.
Not 19, 18. It's 18 days.
And nothing has been recovered.
No. Only that police recorded 161 statement. Some other co-workers is also there.
Heard Miss A. Begum, learned counsel for the applicant, accused, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. This application under section 439 services preferred by accused Rafiq Hussain, who has been languishing in jail Hazard in connection with Hattigao PS case number 24 of 2024 under section 457 T80 IPC, read with section IPC since 27/4/2024, for grant of bail. The above noted case has been registered on the basis of one FIR lodged by one Meenakshi Sharma on when the FIR was filed.
Lordship, it is 18 to 24, but
On
typographical.
18 to 2024, the essence of allegation made in the FIR dated so is that on the night of 18 to 2024, some unknown person have committed theft in our house located at Nilasol Block B and stolen golden bangles, 3 pair, gold ring, 5 numbers, chain, 3 numbers, earring, 4 pairs, and and coins of various countries, and 1 gold ring, and all Indian note, and 10 to 12 pairs of butter cloths. The learned counsel for the accused submits that the accused was arrested on 27/4/2024, and since then he has been languishing in jail, and that nothing has been recovered from his position, and he is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. Gogoi, learned additional PP, has produced the case before this court and submits that the IO has collected some materials in support of the allegation made in the FIR, and therefore Mr. Gogoi has opposed the petition. Whereas, having heard the submission of learned advocates about the parties, I therefore go to the petition of the documents flash and record. And also there is the case ID with the assistance of Mr. Gogoi, learned additional PP. It appears that the accused was arrested on 27/4/2024. And for last 18 days, he has been languishing in jail. And further, it appears that the IO has achieved some progress in the investigation of this case. And in view of the materials collected so far in the case area, further custodial detention of the accused seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with 1 security of like amount with a satisfaction of the learned Chief Judicial Magistrate Kamrup and the accused and learned that case area is related.
Number 30. Number 30.
It is a closure.
Lord, by order dated 21st March, I was granted interim bail. There is a condition that I have to appear before the IO, which I have done.
He appeared lordship, statement recorded lordship.
And I am told, my lord, this
When
statement,
interim bail was granted?
21st March.
21/3.
Thereafter, on 4th April, it was extended.
When it was granted? Interim order when?
On 21st
March.
21st March.
It is not available here. Order is not available here.
4th April, my lord. 4th April, it was extended.
It is available here in the case.
Okay. It is so very nice.
We have seen it on online.
Asked by Honorable Justice P.J. Saikya.
Order dated
21st March 2024 by Honorable Justice P.J. Saikya. Item number 30.
30.
Okay.
3-4.
So what is the stage of investigation?
Lordship statement recorded lordship. In his statement, he stated that he transferred
one piece of land, 9 ledger to the complainant lordship.
There is a cross case also.
To compassionate lordship.
My lord.
Our affair against me has page 18 and our affair is page 20.
It's different.
No, otherwise, what is the stage of investigation? He
Lordship,
appeared and his statement
last note
recorded,
is
that's
that
all.
the case is pending for further investigation.
Further
This is the last note.
Other witnesses examined
Examined lordship.
and the relevant documents were seized.
Documents lordship.
No defendant was found.
One deed of sale of property is, agreement is there lordship.
Or Mr. A.K. Bhattacharya, learned senior counsel assisted by Mr. D.K. Bhattacharya. Oh, you. You.
Yes.
Okay, Mr. S.A. Viswas, learned counsel for the applicant, and Ms. N. Das, learned additional PP for the state respondent, and Mr. You,
I'm on behalf of informant, my lordship.
your good name,
SB lordship.
learned counsel for the informant. Apprehending arrest in connection with Walton Bazar PS case number 60 of 2024 under section 408 IPC, read section 66A IT Act 2000. This application under section 438 CRPC is referred by applicant Ratan for grant of arrest bail. The above noted case has been registered on the basis of an FIR lodged by one Pawan Kumar Mohata on 18/2/2024. The essence of allegation made in the FIR dated so and so is that when Ratan Kaur was appointed as an accountant in the head office of the informant's firm, and he had misappropriated a sum of rupees 35 lakhs.
Facts are stated in paragraph 3 of the petition.
Yes, it is some.
Bank statement or address, and petitioner or address.
Para number?
Okay, that no, no, lordship. Okay.
I have only one. Address of the accused, my lordship, in bank statement, Aadhaar card is different. My lord, address of the accused in Aadhaar card and the bank statement is different, my lord. He did not state his original address, my lordship, while getting the job. Kindly see the Aadhaar card address and the bank statement address, entirely different, my lordship. Even I suspect that the account he was holding, my lordship, it is a fake account because he has given wrong address in the in the bank statement. Kindly see.
Come out in
my
the
lord.
investigation.
My lord, see, that's what, my lord, there may be conspiracy because 84 lakhs, my lordship, has been misappropriated. Kindly see the bank statement address and the Aadhaar card address, my lordship. it is the address of the bank statement is entirely different than Aadhaar card statement.
Gopinath Nagar.
Gopinath Nagar, my lord, but his address is staying in a different place, my lordship.
In statement also, Lordship, in his statement also, Gopinath Nagar, Patashan.
And bank statement will be seen, my lordship. His bank account, different address he has given for shifting the for misappropriating the money, my lordship. He has annexed a bank statement, my lordship. That address may be seen, my lordship.
Sir, AK Bhattacharya, learned senior counsel for the applicant, submits that the applicant was granted the privilege of interim period bail by the order dated 21/3/2024, and pursuant to the said order, the applicant had appeared before the IO on
Next date, but he appeared.
when he appeared before the IO
22/3.
22/3/2024. And that he has been cooperating with the investigating agency, and therefore it is contended that the interim order dated 21/3/2024 may be made absolute in the same terms and conditions. On the other hand, Ms. Anders, learned additional PP, has produced the case before this court and submits that the applicant had appeared before the IO and cooperating with the investigating agency, and his statement is also recorded. However, Ms. Das submits that the IO has collected some materials in support of the allegation made in the FIR. And Mr. So-and-so, learned counsel for the informant, also submits that the amount allegedly misappropriated by the applicant amounts to rupees
53 lakhs.
83 lakhs,
91,830.
and that his address in the Aadhaar card,
Aadhaar card, my lord.
Aadhaar card and in the bank
Bank
statement are different. And therefore, the learned counsel for the informant has opposed the petition. Having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the case diary with the assistance of Ms. Das, learned additional PP. Case diary indicates that the applicant had appeared before the IO and his statement is recorded, and he has been cooperating with the investigating agency. Further, it appears that the IO has collected some materials in support of the allegation made in the FIR, but in view of the cooperation being extended by the applicant with the investigating agency, and as well as the progress of investigation, further custodial detention of the interrogation of the applicant seems to be not warranted here in this case. Therefore, this court is inclined to make the interim order dated 21/3/2024 absolute in the same terms and conditions. Case there will be returned. This heavy instance dispose of.
31.
Case diary not received, Lordship.
After the interim, my lord, I have duly appeared before the IO, my lord, and I have deposed our statement also.
When?
So immediately after interim order, my lord.
So case diary will come from which PS?
Hajo Lordship,
Produce it, we will fix the sorted.
21st Lordship.
Or Mr. J.I. Barwania, Lorded Council Product
Then Lordship on 27th Lordship.
applicant. And Ms. N does learn at additional PG, product state respondent. Ms. Das submits that she has not received the case ID. Accordingly, it is provided that Ms. Das shall produce the case ID before this court on 29.
29 Lordship.
29. Till then interim order dated 18/3/2024 is then extended.
May it please your lordship.
Charges submitted Lordship.
I'm under interim protection by this honorable court by interim order dated 23/2024. So it will grant me 14 days time. I'll appear. Till then, let the interim order continues. That can be my only prayer now.
You have appeared
Yes, otherwise I have appeared
before the IO.
before the IO. After the interim order has been granted, I had appeared before the IO. Accordingly, therefore, the investigation is complete now. Charge sheet has been now, as informed, it's been filed. So my prayer before lordship is that I'll appear before the,
So that's all right. Okay, where is
What?
the FIR?
yes, lordship. FIR is at page 22. So this is regarding the petitioners, both the petitioners, they are government employees working as Mondal. Now this FIR has been filed by the informant alleging that we had given loan to him and because of that loan, now we are asking for interest money and all. However, the case is completely different. We had actually filed the case against the informant earlier, wherein regarding a car and therein,
No,
The-
now we are not concerned with your case.
yes, lordship,
Now we are concerned with only the prosecution case.
yes.
For Mr. Sharma, learned counsel for the applicant. And Ms. Endas, learned additional PG for the state respondent. This application under section 438 CRPC is referred by two applicants. Abdul Khalid and Nurur Zaman Sarkar.
Yes, lordship.
Apprehending arrest in connection with Zuria PS case number 41 of 2024 under section 120B 420 406 385 IPC. The above noted case has been registered on the basis of one FIR lost by one Musharraf Hussain on 20th June 2024. The essence of allegation made in the FIR dated so and so is that. What is the allegation?
Allegation is that we had given him loan and now we are asking for loan amount as well as interest.
Allegation. The essence of allegation made in the FIR dated so and so is that.
I borrowed an amount of 30,000. That's in the first page itself, lordship, of the FIR. Lordship will see. The accused claimed a
That,
monthly interest of
On
5,000.
1/10/2019, he borrowed a sum of rupees 30,000 from Abdul Khalid on monthly interest for his treatment.
And page
But
20,
later on, you have failed to make payment of the loan amount.
I had given the loan. That is his allegation. His allegation is that the informant
You
has
have
taken loan
demanded,
from the accused, from the petitioners.
You have demanded interest at the rate of rupees 5,000.
5,000. That is the allegation, lordship. Page 24, lordship will see. Page 24, the top portion. The allegation is, he is now demanding an amount of more than 1 lakh with interest and is harassing me mentally in various ways. So this is the allegation.
Whether he had paid any amount.
So my entire case is that I had never given him loan. In fact, there is a counter case that was filed by me regarding a sale of a car, for which, in fact, that other person, the informant, had to take bail from this honorable court. And thereafter, he had filed this counter case against me on these allegations, just to somehow create some difficulty against me. Because what he is saying, the loan he took in 2019, and this FIR has been filed by him 2024 after 5 years.
And he had also taken a sum of rupees 10,000 as loan from the accused number 2. Nurul Jamal Sarkar. And now he is demanding a sum of rupees 1 lakh, being the interest of the said amount, and he is being harassed mentally in different ways. Mr. Sharma learned counsel for the applicant submits that the applicant was granted the privilege of interim period bail by order dated 28/3/2024, and pursuant to the said order, he had appeared before the IU and cooperating with the investigating agency. And therefore, Mr. Sharma contended that the interim order dated 28/3/2024 may be made absolute in the same terms and conditions. On the other hand, Ms. Anders learned additional PP submits that she has received the KZD. But no, she has not received the KZD, but as per her instruction, the IU has completed investigation and submitted search sheet. Being search sheet number
53/24 dated 31/3/2024.
and its present applicant. But in view of the submission of learned advocates of both the parties, this court is inclined to dispose of this previous bail application by directing the applicants to appear before the learned trial court and to apply for regular bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, interim order dated 28/3/2024 stands extended. This dispose of.
Has not been there.
He specified, my lord, the cash book, land documents, aircraft documents,
saying
regulation
that
certificate,
Vehicle.
AFC original registration, XUV vehicle, fixed
How
deposit,
it's
AFC
been
limited,
seized, my lord.
AFC
I
limited,
have
etc.
got the seizure memo, my lord. I have been furnished with a seizure
No,
memo.
Mr. Das,
I'm
you
sorry.
produce all those documents to the IO.
Yes.
Huh?
Yes.
And Mr. Pukon, you instruct the IO to seize the documents.
My lord.
Thereafter we'll see. You
But-
produce the updated case.
But
again.
one problem is there, my lord. This is the season.
No, problem is you
Lord-
resolve the problem yourselves with the IO.
My lord,
And you comply with the direction given by the court in writ appeal.
yes. My lord, there is one issue here. My lord, this is the fourth FIR against this person. My lord, there were 3 FIRs earlier against this person in connection with a land grabbing incident. My Nyadipatta land was, my lord, tried to be encroached by some, my lord, land grabbers. And instead of taking action against those land grabbers, my lord, FIRs were registered against me. Thereafter, my lord, civil suit is pending. My lord, there is a direction by the civil court. I'm not residing in my home, my lord, because my entry has been cut. They erected a wall in front of my house. My ingress and egress is restricted. I can go home and whatever document record is there in my home, my lord. I'm staying in a rented house. I'm not in my own house now because of this land grabbing issue, my lord. So that is one problem. Otherwise, whatever document is required by the IO, I will furnish, my lord.
Heard Mr. S.K. Das, learned counsel for the applicant, and also heard Mr. Pukon.
This is the seizure memo, my lord. This is the seizure memo of the vehicle. The IO has said XUV vehicle is not given. This is the seizure memo. This has not been incorporated in the case diary.
While Mr. Das, learned counsel for the applicant submits that the applicant person to order of this court dated 6/5/2024 has been extending cooperation with the investigating agency. Mr. Pukon, learned PP has controverted the said submission by producing the case before this court and submits that he has not been cooperating with the investigating agency and he has not furnished the relevant documents as well as properties of the Assam Flying Club to the IO concern. At this assess, Mr. Das submits that he will furnish all the relevant documents, whatever documents and the properties, whatever is available with him. And the price for granting him some more time, here is accordingly allowed. This is the matter on
24th May.
24th May. Mr. Fukon, learned PP cell returned the case diary to the IO concern and produced the updated case diary before this court on that date. Till then, interim order passed earlier, shall continue.
May, can it be on 27th of May, my
Okay,
lord?
no problem. 27.
My lord. 47?
Much obliged, it is. Deeply obliged.
May it please your lordship. A regular bail application arrested on 3/1/24, around 137 days. Charge sheet filed on 31/1/24, madam. I'm not named in the FIR, my lord. Only the recovery was from my house, so I have been put behind the bar. 136, 137 days, madam.
Yes, sir. Someone appeared on the
Yes,
other day.
Lordship, Legal Aid Council, Lordship, please show it here.
He's available.
Now not available. At two, Lordship,
Two.
will inform.
At 2 p.m.
Wait, please, your lordship. Lordship, I'd like to apologize for not being able to mention in the morning. Lordship, I was stuck in traffic over the San Mari flyover.
Which matter?
Lordship, it's a criminal revision. It's an unlisted matter. Lordship, leftover matter from yesterday. It was listed in court number 22, Lordship.
When do you want?
Lordship, I want the matter to be fixed on 17th, Lordship. It is of grave urgency.
Okay, 17.
Deeply obliged, Lordship.
47?
May it please your lordship, my lord, arrested on 3/1/24, around 137 days. My lord, I am not named in the affair, but I was arrested because the girl was recovered from my home. My lord, charge sheet filed, charge sheet number 12 of 2024. And it was filed on 31/1/24. Affair is at page, my lord, 8.
Whether charge has been framed.
Charge sheet filed, but thereafter, my lord, the records are here, the scan copy is here. But
No, you
charge
can
has been
also go
framed.
through the record.
My lord,
There is no bar in going through the record
no,
by
my
him.
lord, 164 statement, my name was not directly given. In 164 statement, it has been what I have seen from my lord. Charge has not been framed, I think.
Yes, Mr. Gogoi.
Lordship, Legal Aid Council, Mr. Soika is appearing here, my lord.
No, he is for the informant, victim.
Victim.
Yes, Mr. Soikia.
My lord. My lord, 164 statement recorded. And there is an Caesar list, my lord, her registration certificate of SEPA, my lord, that has recorded, that has, my lord, says, along with this, my lord, Aadhaar card. Is reflected, my lord, she is born on 4/6/2008, says, my lord, that is apparent. And 164 recorded, my lord. 164, although there is a no directly name has been taken, but circumstances that has revealed that he is there, my lord. My lord will read the 161 statement of the petitioner, my lord. He has admitted, my lord.
Where it is available?
161 statement, my lord. Scan copy, my lord, next week.
Scan copy.
Thing is that, my lord, we both the families have a good relation. She has came and stayed in my house. That is why I was arrested. At para 5, I have stated, my lord.
Well, let me go to the statement.
Buyer registration bill.
I am Iman Ali.
161 statement.
I am Iman Ali.
So what is the age of the victim?
16 around.
Whether any birth certificate or school certificate was seized?
School certificate, my lord, SEBA registration card, my lord, seized along with the Aadhaar card, my lord. That is on record, my lord.
Hmm.
The main accused, that is Alphas and those who are named in the FIR.
Hmm.
One is Zakir, another is my lord.
Yes.
Okay, we'll see. So till today, you were behind the bar for how many days?
Around 137.
157.
137. I arrested one 93124.
3rd of January.
3-1.
24.
So your contention is that she has not implicated you in her statement under section 164 as well as 161.
Name has not been taken directly, but otherwise my direction he has admitted even 164 also.
Hmm.
Even she has said that I don't know the name of the person.
Okay, we'll
But
see.
in the name of, in the FIR, the names are given. Who has done those work?
No, that is name FIR. Subsequently, he has implicated my lord.
FIR,
There is informant has no knowledge about that, my lord. Initial that projection in the FIR.
FIR is by the informant, not by me.
No, no. Initially, what happened? Initial that incident, my lord, reported in the FIR. My lord. It is subsequent development, my lord. Then therefore, she does not know the name of the concerned person. And 161, my lord, he has clearly admitted even, my lord.
Okay, we'll see.
My lord. Masud.
Timing item 20, Bishop. Timing item 20.
May I please your lordship?
Yes.
My lord, this criminal petition is filed by the petitioner lordship against the lordship order of the learned CJM lordship, by which all the earlier orders passed by the learned judicial magistrate first class lordship giving custody of those seized battle nuts lordship in favor of me was modified lordship. What was happened lordship? Your lordship also lordship in the year 9/5/2022 lordship, one order was passed. Your lordship may kindly see lordship that 2090 bags of betel nuts were seized lordship from my custody lordship. And thereafter, I filed an application for Jimma of those articles lordship before the JAM first class, which was allowed on 9/5/2022, page 62 lordship, is the initial order lordship. Thereafter, lordship, state has filed the criminal petition lordship. Your lordship also had that lordship. Because after that lordship, the matter was referred before the division bench. Then division bench passed yes. If the lordship goods are not produced, then the trial court may give the custody during the time of investigation also. And subsequently, that batch of criminal petitions were disposed of lordship, directing us that we have to approach again the trial court. Then again we approached lordship. Then on 31/7/2023 lordship, learned trial court again allowed lordship our Jimma petition. Your lordship may kindly see lordship. Page 102 is the order lordship passed by this honorable.
Thereafter, judicial magistrate first class has allowed your pair.
Allowed our pair. Page 104.
Thereafter, what happened?
Then lordship, that Jimma was not given to us, and certain conditions were put that we will not use it for human consumption. Then we communicated and lordship entered into an agreement with one industry lordship who regularly used those products which is unfit for human consumption for their industrial purpose. And lordship, we also submitted a representation, detailed representation along with those lordship letter of willingness of that company lordship. But that was not released lordship. Although lordship, thereafter lordship.
No, as per your submission, the judicial magistrate first class also has allowed your pair.
Our prayer was allowed by the judicial magistrate lordship,
Yes.
Learned Elaka magistrate
Yes.
lordship. Then that was not released lordship. Then again we approached. That was not released by the police lordship.
No, in spite of order of the.
In spite of
judicial-
order of the JAM first class.
Yes.
Then lordship, we again approached. Then lordship, after our next approach lordship, the learned JAM first class lordship, your lordship may kindly see page 114 lordship. Order dated 7/9/2023. That it is stated on behalf of the petitioner that since the betel nuts have been found not to be fit for human consumption, the petitioner has made a contract with a company which is ready to buy it for manufacturing products for other use. Now, because of the betel nuts are not handed over by the IO, the petitioner is unable to fulfill the contract. There is no information regarding any revision of order dated so and so filed by the prosecution. IO is therefore directed to comply with court order and hand over the betel nuts to the petitioner as per terms of order dated so and thereafter file a compliance report. Petitioner is directed to go to the PS within 1 week from today to receive the Jimma of the betel nuts. Then lordship, I approached. Then on next date lordship, on 16/9/2023 lordship, page 118 lordship, the Jimma was not given to me lordship. Then again I informed the court lordship. Then court white order dated 16/9/2023 lordship, page 118 lordship, held that white order dated 7/9/2023, IO was strictly directed to comply with the court order and hand over the Jimma of the Arakanus to the petitioner. There is nothing on record to show that IO has filed any revision against the order. The reference of criminal petition number so does not in any manner enable this court to review its own order or the IO to decide the merits of the order. IO is no authority. IO has no authority to decide the correctness of the order of judicial court. The implication of the order has already been goggled by the court and hence necessary condition has been imposed upon the petitioner for receiving the Jimma of the goods. IO is the IO of the case is duty bound to follow the court orders, whether in his opinion the order is correct or not. Hence, the reason mentioned in today's report is not acceptable. IO is directed to comply with the Jimma order passed by this court and to hand over the Jimma of the Arakanus to the petitioner within 15 days from today, from 16/9/2023. Lordship. Then lordship, that was also not complied lordship by the authorities. Then lordship, again I approached the CJM. Then now what was happened lordship? the CGM again taken it as a fresh matter, Lordship, and passed the impugned order, Lordship. After calling the report, Lordship, passed the impugned order, your Lordship may kindly come to page 128.
No, again, a report was called for from the IO
From the IO, Lordship,
by the court below.
by the court below. Lordship.
Why?
Lordship, they are saying that why you are not complying the order. So then, Lordship, IO has, your Lordship may kindly come to page 126, Lordship, which is the report submitted by the IO before the learned trial court. 126 on 6/1/2024, Lordship. In that letter, Lordship, he has submitted submission of representation regarding not relaying the seized Burmese Arakaners on Jimma. With reference to the subject cited, I have the honor to report that during the course of investigation of Dolai PS case number so-and-so, the IO had seized a quantity of so-and-so bags of Burmese Arakaners respectively by Dolai PS so-and-so. The original seizure list was produced before the Honorable Court and made seen. The said seized Burmese Arakaners were kept in safe custody and the samples were drawn and forwarded to the District Agriculture Officer Khachar Silchar and to the State Public Health Laboratory Bamuni Maidan, Guwahati for food safety examination, the report of which has already been collected and kept enclosing with the CD of this case. The reason why the said Arakaners was not relied upon Jimma are as follows. That there are a huge such seized Arakaners are lying under the custody of the Dolai PS and in many other PS of Kachar district. Releasing of such Arakaners which are not allowed for human consumption will tolerate, inspire such many other illegal Burmese Arakaners peddlers. That since the report has received on examination of the samples from Senior Food Safety Officer appears that the contamination and presence of microbiological organisms in the said samples are likely to pose a significant risk to the public health and that the said samples are not suitable for human consumption. That releasing of such Arakaners which are perishable and definitely be supplied among public for human consumption, which will affect the government SOP policy related to public health. For that the illegal peddlers of such Burmese.
Okay, there's the what order was passed by the court below?
Yes, Lordship. Then, Lordship, on the basis of that report, Lordship, the court below modified its all earlier order, Lordship, which they cannot, Lordship. Modifying that order, Lordship, now the court below had saying, your Lordship may kindly come to page 131 of the impugned order, Lordship. In the second paragraph, Lordship. Now, it appears that the seized consignments were loaded in different vehicles. That was observed by the learned court below, Lordship. Whereas in all earlier cases, Lordship, that articles were seized from my godown, Lordship. But now court below opined that that was from vehicles. And now, Lordship, there are three conditions were given, Lordship. That earlier, all earlier orders were modified, giving that questioning my ownership, Lordship. Although there are no such claim within these 2 years, Lordship, from any person that those articles are belonging to him, Lordship. But now, Lordship, for the reasons mentioned, IO is directed to do to ascertain the ownership of the seized ownership in terms of section 457 of the CRPC. And the SOP issued by the police department for giving custody of the seized goods as per the order of the Honorable High Court. Accordingly, the petitioner is directed to appear before the Dolai PS with his documents for verification to assert his right over seized property. After asserting as to who is entitled to get possession of the seized Arakaners, the OC of Dolai PS shall dispose of the seized Arakaners on following conditions. The rightful owner shall receive the custody of the seized Arakaners on furnishing bank guarantee of rupees so and so to the satisfaction of that. The Jimmadar must ensure that the seized Arakaners shall not be used for human consumption. Till that, Lordship, everything is correct. But the Jimmadar shall not dispose of the seized Arakaners without prior permission of the IO concerned. That was also one condition, Lordship. Because, Lordship, I am ready to give, Lordship, any bond, Lordship, regarding those articles, Lordship. But already, Lordship, more than 2.5 years, Lordship, already gone, Lordship. There is perishable item, Lordship. So now, Lordship, in such circumstances, Lordship, I have already entered into an agreement with one JGM Industries, Lordship, which was already verified by the Hailakandi Police, Lordship. And in earlier batch of criminal petitions, Lordship, one Suma Pal, she is also one of the party, Lordship. Her 3,74,000 kgs of veterans already released, Lordship. I have already annexed that letter, Lordship.
Who released it?
That police, Hailakandi police already released after verification of that JGM industry, lordship. That one industry is their lordship, to which I am also willing to send it, which is unfit for human consumption, lordship, for their industrial use, lordship. I have annexed, lordship, page 107 is my letter, lordship, which
So
you are,
these conditions were not in the earlier order.
lordship, there is
This
a condition, lordship.
imposed by the learned judicial magistrate
Yes, lord.
by order dated 8/1/2024. These
Yes,
were not there in the earlier order.
Yes, lordship. That
So,
condition were not there.
Your submission is that the court below cannot impose the condition subsequent.
Yeah, cannot modify the order, lordship, because criminal court had no jurisdiction to modify
That's
its
all right,
own.
but whether that was final order.
In lordship, Jimma petition, this is final order, lordship.
Earlier order was.
Yes, lordship. Earlier order was final order, lordship, because Jimma petition was disposed of, lordship.
Yes, Gogoi.
Only that, my lord, we have received a SOP from the Office of the Director General of Police, my lord. Some conditions, my lord, that.
Yes, clause 15 is very much clear, lord. I am also following the clause.
You have idea.
Yeah, because I have already entered.
No, Mr. Gogoi, you see this, while granting Jimma or rejecting
Yes.
Jimma, this SOP is not binding upon the courts. The IO may follow it, may
It's
not
a-
follow it.
He is bound.
That is his business.
Court's
But the
order,
court
my lord, he is bound.
Not bound to follow this SOP.
He is bound, my lord. Because of, everybody should respect the order of the court, my lord.
No. My contention is, this SOP is not binding upon the court.
No, SOP, my lord, from, that is from, only for, my lord, that, human consumption, on the subject of human consumption.
So, out of these three conditions,
Yes, lord.
I think this condition number 2 is irrelevant.
Condition number 2 is, lordship, up to 2
Shall
is,
not be used for human consumption. You will not use it for human.
I am not using it, lordship,
Ah.
for human consumption.
And then number 3 is Zimmeder shall not dispose of the seized arcana
That
to
is
the
the
prior permission of the
lordship.
IO concerned.
That bar is, lordship, troubling me, lordship, because I want to sell it.
No, as per this condition, did you approach the IO?
Yes, lordship, I have already approached your lordship.
IO.
Yes, lordship, I have already
Then,
approached the IO as well as SP, lordship. SP Kachar, through a representative.
What happened thereafter?
They are not allowing, they are saying that, lordship, no, we will not giving those articles on.
Verbal.
Yeah.
Verbal or written.
And
Verbal,
regarding
it is
this
everything is verbal.
condition number 1, yes, Arakanat, no, this bank guarantee. Are you in a position to furnish the bank guarantee?
Yes, lordship, I am already ready to give the bank guarantee. Only, lordship, my prayer is that, lordship, now as already, lordship,
So,
in,
Gogoi, is there any meaning of this condition number 3?
That condition, my lord, let me guess. Please. Jima shall not dispose of the seized cannot without prior permission. IO. My lord, Jima there shall not dispose.
How can otherwise the entire consignment will spoil?
Yeah, my lord.
What purpose will be served?
Shall not dispose means, my lord, that I sell, etc. included. One 32.
So now what is your prayer?
lordship, my prayer is, lordship,
If we modify the condition number 3,
yes,
then it will serve your purpose.
along with that, lordship, a direction may be given, lordship, to release those articles, lordship, as
That's
per
why.
clause 15 of the SOP, Lordship. I am ready to follow their SOP.
If you could not follow, the condition number third, shall not dispose.
Yeah, along with that, because Lordship, they are Lordship not following their SOP, Lordship. Because clause, your Lordship may kindly see clause 15 of that SOP, Lordship, wherein it is clearly said that Lordship, articles may be that betel nuts which is not fit for human consumption, that may be Lordship released on Jimma on furnishing a Lordship bond that he will not use it for human consumption.
The company key করবে
They are manufacturing of incense stick, mosquito coil. Already that was verified by the Hailakati police.
Where that verification report?
Yes, Lordship, that verification report I have annexed, Lordship.
Page number?
Lordship, that your Lordship may kindly come to page 107, Lordship, which is the willingness letter issued by JGM Industries to me, Lordship.
No, the verification by police.
Yes, and that industry was verified, page 111, Lordship. Page 111, Lordship, that the letter which was issued by the SP Hailakandi to the SP Darjeeling, West Bengal, regarding verification of JGM Industries, Siliguri, Darjeeling, West Bengal.
Why it was addressed to the superintendent of police Darjeeling?
Sorry, Lordship.
Why it was addressed to the superintendent of police West Bengal, Darjeeling?
For verification of that JGM industry, because that JGM industry is situated at Darjeeling, Lordship.
And where that report is?
And Lordship, I have not found the report, but on the basis of report that Jimmanama was given, page 112, Lordship, that goods were already released, Lordship. Because that Lordship inquiry report is confidential. Lordship.
This is different case, not
Yeah,
this
in
case.
different case, but Lordship,
Not
that
in this case,
industry,
matter. This
Lordship,
is not in this.
industry is same, in which Lordship, I am also Lordship in a contract, Lordship, to give those betel nuts, Lordship. And that 3,74,540 kgs of betel nuts already released, Lordship, on Jimma.
Yeah, that is the different case, not
Yeah,
different.
in different case, Lordship. But Lordship, in my case also, Lordship.
In your case, where is verification report?
Sorry, Lordship.
In your case, where is the verification report?
No verification was made, Lordship. Already I have requested the SP, Lordship, to verify if required, Lordship. Otherwise, Hailakandi SP already verified it. So if in every cases, Lordship, the verification is to be done, Lordship. So he may also confirm it for the Hailakandi police, Lordship. Because Hailakandi police already verified it and released the goods, Lordship, that betel nuts, Lordship.
So Gogo, you comply with the SOP? Yes, clause 15.
But that verification report not relates to present case, my lord.
No, that's all right.
As Lordship, the SP may verify that industry, Lordship, again, within certain time limit, Lordship, and thereafter, Lordship, that goods may be released. Or Lordship, as per SOP, Lordship, the condition is that I have to give the undertaking, Lordship, that I will not use it
Not
for
used
human
for
consumption.
human consumption.
So I will ready, Lordship, to give such understanding, and after releasing those goods to that industry, Lordship, I will hand over the compliance report, Lordship. Because that verification will take some more time, Lordship.
Where is the first order issued by the judicial magistrate first class?
First order, Lordship. First order 9/5 at page 62, Lordship, 9/5/2022. Initial order. Page 62.
And the second order?
Thereafter, Lordship, after referring this court, Lordship, then second order at page 104, Lordship, 31/7/2023, Lordship. Then third order is page 114 lordship, 7/9/2020. 114 lordship. Giving the IO to comply, giving the IO lordship strictly directed to comply the order. Then lordship, last one, page 118, 16/9/2023 order lordship. Fourth order lordship.
And the impugned order is a page number?
And impugned order is lordship at page 128 lordship. 8/1/2023.
So Gogoi, you verify the proposal given by him.
My lord.
And thereafter, no, as per this SOP, where the report is to be submitted before the court.
Oh, my lord.
If the claim is genuine, then the court should be requested to impose strict condition to ensure that the betel nuts are used as per claim and not for human consumption. That the superintendent of police should get the claim verified and report to the court.
Yes.
If the claim is genuine, then the court should be requested to impose strict conditions.
But it's no such report, my lord, I think, my lord.
Available now.
Yes, that is not, I have not found.
No, as per his submission, it is verified.
Now, verified verified report might not relates to present case, my lord.
Maybe
Some
lordship, but
other
that
case.
industry was already verified. by
Industry verified
Assam
in
Police.
other case, not present case, my lord. Now, my friend says that we have contact with that Darjeeling factory.
Yeah.
But that is his verbal submission.
No, that lordship, may I pray lordship, that as lordship, that JJM industry already verified by the superintendent of police, Hailagandhi lordship. So let
No,
lordship, the SP Khachar,
verification of not that interest, verification of your claim that you will sell the seized Areca nuts to that company.
that may be verified
That
lordship,
claim
with
has
it,
to
but
be verified.
certain time limit may kindly be given.
Pardon?
Lordship, certain time limit may given lordship, because otherwise lordship, again, some time.
Then
will be
you have to
considered.
approach that police. You have to approach.
Your lordship may direct lordship that the SP Khachar may verify that industry lordship regarding my claim lordship, and on such report lordship, my consignment may be released lordship, and entire lordship process may be taken about 2 months or 3 months, anything. But
Because
one end lordship, that has to be end.
dispose no word. Today it will not dispose.
Heard me, sir, your good name?
NH Borbuyal.
NH.
NH Borbuyal.
Learned counsel for the petitioner and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. In this petition, under section 482 CPC, the petitioner has challenged the correctness or otherwise of the order dated 8/1/2024. Passed by the learned Chief Judicial Magistrate Kasar Silsor. It is to be noted here that by impugn order dated 8/1/2024, the learned chief judicial magistrate has modified the order passed by the learned judicial magistrate first class Silsor dated 31/7/2023 in Dholai PS case number 49 of 2022. And orders dated 7/9/2023 and 16/9/2023. The background facts leading to filing of this present petition is enumerated herein below. The petitioner is the businessman of which place?
Silchar Lordship.
Kasar Silchar. And he deals with the business of betel nut, stroke erica nuts. On 7/2/2024, the officer inserts Dholai PS has ceased what is the quantity of betel nut seized from your possession?
Lordship, that is approx 2090 bags of.
Where you have mentioned it in your petition?
Lordship, paragraph 4, Lordship.
Paragraph 4, that is 490 bags from
490 bags
Nizamuddin.
betel nut, Lordship. Then on the very seized 100 bags. Then Lordship.
No, unless it is disposed of in time, the same will perish and will be rendered useless. Under the aforementioned facts and circumstances, this court is inclined to dispose of this petition by directing the petitioner to make a written prayer to the IO of the present case. IO of the present case, and also to the superintendent of police, Kasar Silsor, and on receipt of which the superintendent IO and the superintendent of police shall verify the claim of the petitioner, and if the claim is found to be genuine, then the IO and the superintendent of police shall release the seized articles, seized erica nuts, 2090 bags in favor of the petitioner. Petitioner, on compliance of the conditions so imposed by learned chief judicial magistrate Kasar Silsor, White impugn order dated 8/1/2024. The entire exercise has to be carried out by the superintendent IO stroke superintendent of police Kasar Silsor within a period of 2 months from today. In terms of above, this criminal petition dispose of.
I love it.
Standing item 22.
Yes, Lordship, here the notice served, my lord, notice served. we have, my lord, telephonic instruction.
No, you produce the report
Report then, my lord, then let it come on the day after tomorrow, my lord.
Friday.
day after tomorrow,
Yes.
Friday.
Right.
Mr. Gogoi, learned additional PP submits that as per his instructions, a notice upon the respondent number 2 has already been served. But he prays for listing the matter on Friday so as to enable him to produce a written report from the officer in charge concerned PS in respect of service of notice upon respondent number 2. There is accordingly allowed. Rest is list the matter on Friday.
Public.
Here, notice not served, my lord.
Whether it is received by received by
Telephonic instruction দিছে।
notice পাইছে তো?
নাই নাই, সেইটো serve কৰিব পৰা serve হোৱা নাই বুলি কৈছে, notice পাইছে নে নাই মই ইমান details notice not served.
No, not that, that's all right, but whether they have received the notice or not.
That is, my lord, actually my office clerk has communicated with him, my lord. He informed me that notice not served.
Whether notice is received by IO or not.
আপুনি এটা কপি মোক এক্সট্ৰা দি দিব, এনেওতো আজি হোৱা নাই, এটা এক্সট্ৰা কপি দিব, মই communicate কৰিম।
May I pray one alternative proposal, my lord? A legal aid council may be appointed for the respondent number 2.
No, legal aid counsel can be appointed, that's all right, but only when nobody appears after receiving the summon, receiving the notice.
Then only. Now, my friend will
Yes, sir.
supply one another copy, my lord. I will
Furnish a copy to him
Today
today
itself.
itself.
Today itself I am, sir.
Mr. B.B. Gogoi, learned additional PP submits that as per his instruction, notice upon the respondent number yet to be served. In view of above, it is provided that Mr. Gogoi, learned additional PP shall produce a report
Yes, sir.
in respect of service of notice upon respondent number 2 on Gogoi when?
Monday, my lord.
Next Monday,
20, yes.
20.
Yes.
20. You furnish a copy to.
Yes, well, today itself I will be providing. Other than that,
Item 48. May please. 438 application, my lord, by interim order dated 13/3/2024, my lord.
Gogoi city receipt?
I have appeared before the
Yes.
statement has been recorded, my lord.
Yes, sir. This statement recorded, my lord.
Lordship will find him.
What is the stage of investigation?
Yes, he has appeared, my lord, his statement recorded, my lord. Some allegation is there, my lord, it was caught from the Chokidar and he is saying that on the instruction of present petitioner, my lord, that is the.
No, that's all right. What is the stage of investigation? Is it
Investigation,
about
my
to
lord,
complete or is still going on?
not complete, but almost, my lord,
Completed.
almost, that is, my lord. Because main person, my lord,
Mr.
he has
P.
been arrested.
Hazarika, learned counsel for the applicant, and Mr. B.B. Gogoi, learned additional PP for the state respondent. That's pair number 20. Mr. Hazarika, learned counsel for the petition applicant submits that his court was pleased to extend the privilege of interim periods bail to the applicant by order dated 13/3/2024, and thereafter the applicant had appeared before the IO on.
Yes,
No, as per your instruction.
I have instructed that he has appeared, my lord. I think that is not.
here, my lord, 16/3.
He had appeared before the IO on 16/3/2024 and cooperating with the investigating agency, and therefore it is contended to make the interim order dated 13/3/2024 absolute in the same terms and condition. Whereas Mr. B.B. Gogoi, learned additional PP, submits that the IO has collected some materials in support of the allegation made in the FIR. However, Mr. Gogoi confirmed that the applicant had appeared before the IO and cooperating with the investigating agency, and investigation of the case is about to complete. is about to complete. Then having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Gogoi, learned additional copy. Case diary indicates that the IO has collected some materials in support of the allegation made in the FIR. But it appears that the applicant had appeared before the IO and cooperating with the investigating agency. Further, it appears that the IO has achieved substantial progress in the investigation of the case. And in that view of the matter, custodial interrogation of the applicant seems to be not warranted here in this case, and accordingly, this court is informed to make the interim order dated 13/3/2024 absolute in the same terms and conditions. Evidence dispose of CDB return.
I'm obliged. Item 37, matters for orders. 37.
None appears for the appellant from 12.
It's 19 meter, Lordship. I think that legally reached my lord, Mr. A. Borua, so whether he is now in the list or not, my lord, I don't know.
It appears from the record that one Mr. A. Borua, learned counsel, who was appointed as legal aid counsel. But today also he remained absent without stay. No, no. Today also he remained absent on repeated call. Further, it appears that this jail appeal is deferred in the year 2019. Under the aforementioned facts and circumstances, this court deemed it appropriate to engage another legal aid counsel to represent the case of the appellant. Accordingly, it is provided that Mr. P. Soikia be appointed as a legal aid counsel. Rest shall reflect the name of the learned counsel, Mr. Soikia, in the cause list and furnish a copy of the paper book to him well in advance. Rest shall list the matter on 6.
Item 38.
Please, Your Lordship. The last Loazima course order shows that respondent number 6 and 8 service return back, Lordship.
Service?
Service reports show that this notice return back for not availability of the addressee at that address, Lordship. Lordship, we have served the notice as per the FIR address. This is the case, Lordship, for amalgamation of multiple FIRs, Lordship. So all our other respondents appeared only 6 and 8. And we have served the notice as per the address mentioned in the FIR. But
where is that FIR?
FIR, Lordship. One is, Lordship, respondent number 6, Lordship. FIR page 41, Lordship. In the column number 6, Lordship, complainant and informant, here informant.
Original FIR.
Original FIR, Lordship, page number 43, Lordship, by one organization. And his address is mentioned in page 41, and in that address, Lordship, we have issued served the notice, but return back unserved, Lordship. And similarly, also respondent number 8 also. In the cost title, we have mentioned the address. Same address, Lordship.
Padum Sharma is the advisor.
Advisor, Lordship, and in the FIR it is mentioned, Lordship, page 41,
You
Lordship.
served notice to this General Secretary,
Lordship. And
Tarun Datta.
but in the page 41, he's
So that office might be available at this where it is situated.
Lordship.
Wasim Baragaon.
Here in the address mentioned, Lordship, and in the cost title, same address I have mentioned, that's the problem, Lordship. And similar, Lordship, to the respond number 8, Lordship. If you, Lordship, see this cost title, Lordship, same address, Lordship.
That's already you take a fresh system.
Otherwise, Lordship, main respondent is the state, Lordship, so because matter is regarding amalgamation of affairs, Lordship. All affairs, Lordship.
Maybe, but if we pass the order,
Yes, Lordship.
then someone will again point it out that without hearing us, the order was passed.
But
Then
just
if somebody approves the Supreme Court will set it aside.
yes, Lordship, that problem may arise, Lordship.
What purpose will be
But
served then?
I think, Lordship,
Better
since the address is
you,
the same as mentioned in
you
the
made
FIR.
another attempt to post service of notice, you
See-
can serve it by dusting wood also, though we cannot permit you.
Lordship.
The office might be available at
Yes.
Wasim Baragaon.
Respondent number in respect to respondent number 6, we can attempt to the office, Lordship, and it
Yes,
is
6 and 7.
6 and 8, Lordship. And
No, 6
in
and 8.
this in the scope of
6 to 8 or
6
6 to
no,
9.
7 is completed, Lordship.
Huh?
7 is completed. 6 and 8, Lordship, may kindly see the Lawazima course order 10/4/24. There it
7
is.
and 8.
7 and 8.
7 and
There
8
is
is it
24,
like
9
Antar?
is 9.
No, in the lower column, lower line, 6, 7, 8, and 9. Neither the ID card nor the unserved notice returned.
9 is appearing, Lordship.
9 is appearing.
Yes, 8 has also filed Okaratnama earlier in the office note I have found, Lordship. Only 6 and 8 remains, Lordship. 6 is one person from an organization and 8 is a personnel, Lordship.
So 6 and 8.
Yes, Lordship.
6 is Padum Sundar Sharma.
So, in regarding 6, we can attempt to in the office
Yes.
to serve to the office, but regarding 8, Lordship, there is no
7.
office, his personal capacity is filed. He
So is it
this is
correct to
also Lordship.
mention this
This is also
in
by
the FIR it is mentioned as Mohendra Das. And in the cost title it is Madhav Das. Is it correct?
Respond number 8, Lordship.
7.
7, Lordship. 7, I think service completed, Lordship. We are there.
8. Then 8.
8, Lordship.
Ika Kamrupa.
There is also an office address, Lordship. Kutumba Surakha Mission, one organization. In both cases, we can attempt to the through office, Lordship.
My lord, otherwise on 10 April 2024 in the Lawazima court, when the matter came up, the learned counsel appearing on behalf of the petitioner submitted that the name of the respondent number 6 and 8 may be struck off and prays for the matter to be placed before the honorable court. That prayer was made, my lord.
Yes.
If Lordship staff of Justice Lordship have pointed that in future a problem may arise because since they are informant. So again, if they come. So we can
So
attempt,
you make a fresh attempt.
yes, Lordship, we
about
can attempt
6 and
through
8?
office address of that organization. Lordship. Regarding 6 and 8.
Heard Mr. Your
J. Abbas, Lordship. J. Abbas, Lordship.
J. Abbas, learned counsel for the petitioner and madam.
U Sharma for respondent numbers 1 to 5.
You Sharma, learned counsel for the respondent number 1 to 5. You are appearing in as government
For the
advocate.
government
Government
officer,
advocate.
government advocate.
For respondent number 1 to 5.
1, 2, 3, 4, and 5. 1 to 5.
1, 2, 3, 4, and 5. And Mr.
M alarm for respondent number 9 notes.
M. Alam, learned counsel for the respondent number 9. Mr. Abbas, learned counsel for the petitioner submits that though a pair was made before the Lawazima court on 10/4/2024, that the name of respondent number 6 and 8 may be struck off. Yet he is not willing to pursue the aforesaid submission, and he is willing to make a fresh attempt to cause service of notice upon respondent number 6 and 8. Accordingly, it is provided that Mr. Abbas, learned counsel for the petitioner, shall take fresh step upon respondent number 6 and 8 by registered post and also by usual process within a period of 2 working days from today. Regis shall list the matter after
On 10 June.
10 June.
I have to serve in new address because in the official paper.
Respondent.
আজি মই অকমান আগতে ক'লে মই ফোন কৰিলো অলপ আগতে ক'লে
নেক্সট টাইম
কাৰণ আমি ইমান মিষ্টেক নকৰো নহয়
সেইকাৰণে মনত কৰাই দিলো
Office note dated 9/4/2024 indicates that step upon respondent number 2 is taken for the learned additional PP.
এক্সট্ৰা কপি আছে নেকি
ইমান ডিমান্ড লগত নাই
কি কৰিম আইটেম মোৰ লগত নাই মই কি কৰিম
Accordingly, it is provided that Mr. Gogoi, learned additional PP, shall obtain a report, written report from the officer in service, Gograpar Police Station, in respect of service of notice upon respondent number 2 on next day. List the matter on
30 May.
short date.
27 May.
That will do, madam. Or if on the next date, madam, suppose services or company amicus curiae may be engaged, madam, we can proceed.
Let the report come.
Yes, ma'am.
43.
I filed for granting bail to the accused appellants, nearly 215 days they are in custody, The appeal is admitted. Your Lordship, the proof the husband and wife have been arrested, sent to the jail on the day of judgment. That is 12/10/23. And by going to the judgment, your Lordship may look into the appeal, appeal. Page 28.
He is inside.
Both husband and wife.
12/10/23.
All right. 15 days man as well.
LCR has been received.
My lord.
LCR is received.
LCR.
Yes.
Oh, received.
Listen.
So what are the grounds?
My lord, ground is that, my lord, if we go by judgment, my lord, that 313 and 328. IPC, my lord, do not attract, my lord. It's page 28 in the appeal, my lord. My lord, for that, we have to go through the
No,
judgment.
you have been convicted under section 498A.
Yes, 498A also is there.
And
But then
313.
313, then 511 and 328 and 34 IPC.
So we can finally hear and dispose of the petition and the appeal also.
Yes, if bail not granted, then appeal may be hard, my lord.
No,
And
not in a piecemeal way. We'll hear both the matter together. So mainly, what are the grounds?
the ground is that 313 and 328, which are the main, my lord, section of IPC. Those not attracted, my lord, here in the case.
Why?
Why? Because neither that liquid whatever administered to the, my lord, victim woman, my lord, there is no medical report as such. And your lordship, that's why, my lord, if your lordship go by the judgment, kind of for a moment, my lord, go by the judgment.
Page number?
Page 28 of the appeal. Page 28 of the appeal.
28.
Yes.
Evidence peruse.
Yes, evidence peruse. There is page 28. Then the para 8, my lord. Have a little God, my lord. May I read, my
PW1.
Yeah, PW1 Dr. Paramita Roy, in her evidence, deposed that on 29/1/16, while she was working as a resident physician, Department of Medicine, Silchar Medical College Hospital, on that day, she examined the victim, Rafia Begum, and on examination of abdomen, she found uterine fundus palpable up to umbilicus. Her cardiovascular system was found normal. On the basis of pupillary constriction of the patient, she had inferred that she might have consumed some pesticides. She also stated that she gave medicines to her and also got done gastric lavage, stomach washing. As the patient was carrying pregnancy, she had also called a doctor from gynecology department of their hospital for her examination. She also stated that the patient was discharged. After just examination, she was discharged from the hospital with the diagnosis of suspected ingestion of unknown substance, suspected to be organophosphorus and anemia, and of 6 months pregnancy. Then in cross your lords will find. Sorry, no. Then PW3, which was examined at page 30, your lordship will find. Page 30, para 10. If we go by these two, my lord, then 311, 13 and 320 doesn't come. 10, my lord. PW3 Halima Begum.
No, you were referring to this cross-examination of the doctor PW1.
A cross-examination. In her cross-examination, she stated that she had not, preserved the gastric lavage of the patient, as in their hospital there is no such facility. So that liquid, whatever the gastric lavage, was not sent to FSL for chemical examination, and that she gave symbolic treatment to the patient. Only this much is the medical evidence. Then your lordship, para 10 of the judgment.
And what's this?
So the
victim says what? PW2, PW2.
Yes, I'll come. Just then para 10. Para 10, your lordship, PW3 Halima Begum disclosed that about 3 years ago at about 6 p.m., the incident took place. She disclosed that her matrimonial house and that of victim matrimonial house are situated adjacent to one another. It is stated by this witness that hearing the cry of the victim, she, along with her other sister-in-law and mother-in-law, rushed to the house of the accused and found Rafia Begum on the courtyard of the accused person's house, lying unconscious. Thereafter, the three of them lifted Rafia Begum and brought her to matrimonial house, and in the meanwhile, her father-in-law came from the market and took the victim first to the Kaligans MPHC, from where she was referred to Karimganj Civil Hospital and then to Silchar Medical College Hospital. She disclosed that she was informed about this by her uncle Kamaluddin, who had accompanied her father-in-law and the victim. She also stated that since the marriage of Rafia Begum, they were not in visiting terms with the accused, but she used to meet Rafia near a nearby pond, where she used to tell her that her husband and his first wife wanted to abort her pregnancy. She also stated that after 8-9 days of the institution of the case, the victim gave birth a child. So, my lord, 313 and 320, she has gave birth a child, my lord, a normal child she has gave birth, this victim of man. How this 328 giving poisonous to...
Okay, agreed that 313 is not attractive, but 498A?
If 498 for that it is available, it is available. 498
Mostly it is provided that registration list this criminal appeal and criminal IA criminal 127 on 2023 on 4th June. On that day, both the matters will be heard together.
endeavor we made to dispose
Okay,
that.
Yes, yes.
Together and endeavor will be made to dispose of the same.
Right.
44. 44.
May I please, your lordship? Leave petition is filed for appeal against acquittal, my lord. The complaint was filed under section 138 NI Act, my lord.
Okay, we will issue notice.
My lord,
We will issue notice.
my lord.
Heard Mr. A. Halim.
As Alim.
S. Halim, learned counsel for the petitioner, and Mr. B.B. Gogoi. No, state is not a party here. No. Mr. B.B. Gogoi, learned additional PP for the respondent number 1. This application under section 378, question bracket 4 of the criminal procedure is preferred for granting leave to appeal against acquittal by impugn judgment and order dated 26/10/2023 passed by the learned Chief Judicial Magistrate Kamrup Metro Guwahati in sphere case number 4774C 2019. It is to be noted here that by the impugn judgment and order dated so the learned court below learned trial court has acquitted the respondents number 2 and 3. Respondent number 2 and 3. Respondent opposite party number 2 and 3. From the offense under section 138 NI Act. Peruse the petition and the documents placed on record. Let notice be issued to the respondents, returnable in 4 weeks. Step upon respondent number 2 and 3 be taken by registered post and also by usual process within a week from today. No formal notice to respondent number 1 since Mr. Gogoi learned additional PP appears and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. List the matter after for its
Obliged, my lord.